I'm Bob Friedrich, your host for the Co-op Condo Brief. I am president of Glen Oaks Village, the largest garden apartment co-op in New York, and also founder and co-president of the President's Co-op and Condo Council, a leading voice for co-ops and condo owners. We're comprised of more than 100 board presidents throughout the 5 boroughs of New York City. The Co-op Condo Brief is your inside track on today's issue, and today's issue is the New York State Climate Leadership and Community Protection Act, also known as the CLCPA, which was signed into law on July 18, 2019 by the Cuomo and Hochul administration. It commits New York to major reductions, or better yet, impossible reductions in greenhouse gas emissions. This was the same year the New York City Council passed Local Law 97. Both the state and city working in tandem to threaten affordability and put citizens' stability at risk. Let's break it down and consider what it means for all of us. Number one, New York State must cut emissions by 40% by 2030. Think about that, 40% by 2030, 85% by 2050. And that's all based on 1990 levels. Even worse, it mandates a switch to 70% renewable electricity by 2030 and 100% zero-emission electricity by 2040. But here's the rub. According to Con Ed, almost 70% of our energy still comes from fossil fuels. That's actually higher than when the law was first enacted, largely because Governor Cuomo shut down the Indian Point nuclear plant, which had supplied 25% of New York City and Westchester's energy needs. And that was clean energy. So rather than making progress, we're actually taking a step backward. Now, with just 4 years to go until 2030, we would need to double our renewable capacity, which is a massive transition shift. A generational transition shift, all within an unrealistic political timetable that spells trouble for all of us. The New York State Energy Research Development Authority, also known as NYSERDA, recently issued a report that doesn't sugarcoat the situation. The report states that making this transition is practically impossible under the current timeline. In an ominous warning, the report states that, quote, upstate oil and natural gas households would see costs in excess of $4,000 a year, and New York City natural gas household customers could anticipate annual gross costs of $2,300. That's a $200 increase in your monthly utility bill, and you thought your current electric bill was high. On top of that, gas prices, and I'm quoting, gas prices would rise by at least $2.23 per gallon above the current rates at that time, putting us on par with California's notoriously high prices. Simply put, this law would inflict serious financial harm on us. This pain is in addition to the onerous and crushing penalties of Local Law 97, which I discussed in a previous podcast. Even the New York State Attorney General's office weighed in on a court case, Citizens Action of New York versus New York State Department of Environmental Conservation. In an August 11, 2025, detailed 7-page letter, the Attorney General's office argued that New York's climate law goals just aren't achievable in the short term. They called the targets, quote, infeasible, and warned that they, quote, would impose significant damage to the public interest by imposing unanticipated and undue costs on New Yorkers. The letter states that achieving the goals of the CLCPA would, quote, impose extraordinary and damaging costs upon New Yorkers, close quote. They put the energy cost at an additional $42 billion per year, and that still would not meet the 2030 goal of the climate law. Ultimately, the Attorney General concluded that the 2030 target is, quote, not practically feasible due to costs consumers simply cannot bear. Think about it. That's the Attorney General who's telling us this. Less than 6 months ago, on October 20th, 2025, a dozen state legislators, all Republicans, wrote a letter to Governor Hochul begging for a temporary halt to the climate law. To me, it's inconceivable that every assembly member and state senator would not have signed on to this letter, especially knowing the effects this law will have on their constituents. And why does this all matter? Because as ratepayers, we're the ones footing the bill. Common sense is being drowned out by rigid climate ideology in both New York state and city governments. This is insanity run amok. Co-op presidents like myself and other leaders from communities such as Co-op City, Beach Hills, Clearview Gardens, Bay Terrace, and many others are in the trenches fighting for our families. It's not a pleasant battle, but it's one we can't afford to lose. Thank you for watching, and now you have the inside track on today's issue, the New York State Climate Leadership and Community Protection Act.